Hi, it's Nate Charles, and welcome back to the Rule of Law Brief. I want to talk briefly today about a letter that Senator Josh Hawley recently sent to the Attorney General of the United States, asking the Department of Justice to open an investigation into protest activity related to immigration enforcement. There is one narrow point in this letter that is legally correct, and I'll acknowledge that up front. If foreign actors are funding, directing, or controlling political activity inside the United States, that can, and frequently does, violate the Foreign Agents Registration Act and related laws. That is true. I know that because I used to prosecute those kinds of cases. But that is where the legal accuracy of this letter ends. Before I explain why, I want to be clear about my perspective. I previously worked in the Counterintelligence and Export Control section of the U.S. Department of Justice. That office exists because of one of the most serious failures in American law enforcement history, COINTELPRO. COINTELPRO was the FBI's Cold War era counterintelligence program. It was eventually exposed, investigated by Congress, and condemned because it involved the FBI using investigative powers to suppress lawful political dissent. Civil rights leaders, protest organizations, and political movements were targeted not because they committed crimes, but because the government disliked their views. It was one of the most serious forms of viewpoint discrimination. The FBI's own documents describe the objective as to expose, disrupt, misdirect, discredit, or otherwise neutralize domestic political movements. That history is not disputed. As a result of those abuses, the modern FBI and DOJ framework was built to operate, at least on paper, under strict constitutional restraints. That history matters because the rules that govern the FBI today exist precisely to prevent a return to that kind of conduct. Under the FBI's Domestic Investigations and Operations Guide, the DIOG, even the lowest level of inquiry may not be opened based solely on First Amendment protected activity. Lawful protests, political advocacy, organizing, and opposition to government policy cannot, standing alone, serve as the basis for an investigation. For preliminary or full investigations, the FBI must have an articulable, factual basis indicating criminal conduct or a legitimate national security threat. Suspicion, ideology, and political disagreement are not enough. Now, let's take a look at Senator Hawley's letter. It didn't identify a foreign principal. It didn't identify a funding stream. It didn't identify directives, intermediaries, or transactions. All it identified is protest activity and political messaging. In other words, First Amendment protected speech. The letter asked DOJ to infer foreign influence without evidence and to investigate Americans because of their political opposition to government policy. That is exactly the kind of request the post-COINTELPRO rules were designed to prevent. The FBI is not allowed to investigate Americans because elected officials don't like what they're saying. That principle is not a loophole, it's a safeguard, and one we've learned the hard way, time and time again.